3 years of federal tax, payroll, rent, utilities, none of it deductible. For one New Mexico cannabis company, that is the bill they just asked a federal court to refund. Every other state licensed medical operator in America has the same money sitting on past returns. The deadline to ask is already running. Today on Pat Talks Law, the case, the hook, and the filing that decides whether you collect. The company is Ultra Health, legal name New Mexico Top Organics, doing business as Ultra Health, the largest state licensed medical cannabis operator in New Mexico. The case is New Mexico Top Organics versus the Commissioner of Internal Revenue, pending in the United States Tax Court. Ultra Health filed its petition in December of 2024. At that point, cannabis was still listed in Schedule 1 of the Controlled Substances Act. They asked the tax court to find that Section 280E does not apply to them for tax years 2017, 2018, and 2019. They want refunds on the federal income tax they overpaid in those 3 years. On May 18, 2026, their counsel, Nathaniel Pollock, filed a seriatim reply brief. The brief asked the court to weigh one new fact. As of April 22nd, 2026, state licensed medical cannabis is listed in Schedule 3. If these breakdowns help you cut through the noise, hit subscribe. Pat Talks Law goes deeper every week. Congress wrote 4 words into Section 280E in 1982. The statute disallows deductions for any trade or business that consists of trafficking in a controlled substance within the meaning of Schedule 1 or 2. The phrase is within the meaning of. Congress had options listed in, classified as. It chose within the meaning of. Ultra Health argues those 4 words are doing real work. HHS concluded in 2023 that cannabis has currently accepted medical use and lower abuse potential than any substance in Schedules 1 or 2. President Trump's December 2025 executive order directed the Attorney General to complete rescheduling. The acting AG signed that order in April. The federal government's position across 2 administrations is that medical cannabis does not fit within the meaning of Schedule 1. Ultra Health says the court does not need to perform a fresh rescheduling. The federal government already did. The IRS disagrees. In its March answering brief, Acting Chief Counsel Kenneth Keyes argued the tax court is being asked to perform a de novo rescheduling it has no authority to perform. The brief calls Ultra Health's reading an elephant in the mousehole of the within the meaning of verbiage. Ultra Health's reply, filed May 18th, is that the rescheduling already happened. The court is being asked to interpret the words Congress wrote. Stay with me. None of this matters unless you are inside the statute of limitations to ask for the refund. The rule is in Section 6511, 3 years from the date you filed the return, or 2 years from the date you paid the tax, whichever expires later. For a calendar year operator who filed 2022 returns by April 15th of 2023 with no extension, that 3 year window closed on April 15th of this year. For operators who extended to October, the window closes in October, even if Ultra Health wins the case. Even if Treasury issues guidance that retroactively unwinds 280E. If you did not file a refund claim or a protective claim before your window closed, you do not collect. The clock does not wait for the case to resolve. Step back. The rescheduling order Blanche signed in April did more than reclassify medical cannabis. It asked Treasury to consider providing retrospective relief from Section 280E liability for taxable years in which a state licensee operated under a state medical cannabis program. That guidance has not landed. Ultra Health's case could force the question. If the tax court rules that medical cannabis did not fit within the meaning of Schedule 1 during the closed tax years, every other state licensed medical operator with a preserved refund window is positioned to collect. If the court rules the other way, the industry waits on Treasury. 2017, 2018, 2019, 3 closed tax years, carrying the bill for one line of the 1982 code. If you are a state licensed medical operator with open tax years, the protective refund claim is the move you make this month. The tax court ruling will not preserve your statute. Treasury guidance will not preserve your statute. Only your filing does. Talk to tax counsel who has filed Section 280E refund claims before. Make sure the claim preserves every year you can still preserve. I'm Patrick Nolan. This is Pat Talks Law.